Hello everyone and welcome to the Firearm Firm channel. Finally, there's something good coming out of California in regards to the Second Amendment. Last week, Judge Benitez from the United States District Court for the Southern District of California issued an order finding California's large capacity magazine ban to be unconstitutional. So let's take a couple of minutes today and discuss this well-written order. But before we do, be sure to show your support for the Second Amendment by hitting that like button. And don't forget to subscribe to the Firearm Firm channel by clicking on the subscribe icon located down in the bottom right hand corner of this video if you have not already done so. Well, I can honestly say I thoroughly enjoyed reading this 71-page order written by Judge Benitez, which was issued last Friday, September the 22nd in the case of Debunking versus Bonta. Now, this case has been around since 2017 and has had a lot of things going on in it, including making its way all the way up to the United States Supreme Court, which sent the case back down to the trial court for further proceedings consistent with the 2022 ruling in New York State Rifle and Pistol Association versus Bruin. The issue in this case was whether or not California Penal Code Section 32310, which bans so-called large capacity magazines, LCMs, was constitutional. According to the statute, any magazine that holds more than 10 rounds is considered a large capacity magazine. Judge Benitez wrote in the introduction of its order that this case is about a California state law that makes it a crime to keep and bear common firearm magazines typically possessed for lawful purposes. Based on the text, history, and tradition of the Second Amendment, this law is clearly unconstitutional. He goes on to say there is no American tradition of limiting ammunition capacity, and the 10-round limit has no historical pedigree and is arbitrary and capricious. It is extreme. In stealth return to the interest balancing test rejected by Heller and Bruin, the state ostensibly justifies its magazine limits by deeming the smaller magazines well suited for its citizens. Suitability in turn is based on concocted statistics about what a hypothetical average person needs to defend against an attack or attackers in an average self-defense situation. Based on this hypothetical, statistically average case scenario, the state permits its citizens to have a gun, but the state decides the number of rounds in the gun that is suitable. In so doing, the state denies a citizen the federal constitutional right to use common weapons of their own choosing for self-defense. There have been and there will be times where many more than 10 rounds are needed to stop attackers. Yet, under this statute, the state says, too bad. It says if you think you need more than 10 chances to defend yourself against criminal attackers, you must carry more magazines or carry more bullets to hand reload and fumble into your small magazines while the attackers take advantage of the pause. On the other hand, you can become a criminal too. So the previously law-abiding California citizen who buys and keeps at her bedside a nationally popular Glock 17 with a standard 17-round magazine becomes the criminal because the state dictates that a gun with 17-round magazine is not well suited for home defense. All of this great language can be found in the first 6 pages of the 71-page order, which of course I will attach a link to the full order down in the description section of this video. All right, let's get to the meat and potatoes of this order. The first issue is whether or not magazines are protected arms. So the state of California first argued that magazines are not essential to the use of firearms and therefore they are just accessories. But don't worry, the court thought this position was just as dumb as you and I think it is. The court noted that while the Second Amendment does not explicitly mention ammunition or magazines supplying ammunition, that without bullets, the right to bear arms would be meaningless because the right to keep firearms for protection implies a corresponding right to obtain the bullets necessary to use them. The court found that because bullets are necessary to fire a firearm, it would be hard to imagine something more closely correlated to the right to use a firearm in self-defense than the ability to effectively load ammunition in the firearm. After that argument didn't work, the state then made 2 additional arguments. First, although a magazine of some size may be necessary, a magazine that holds more than 10 rounds is not necessary to operate a firearm, and therefore large capacity magazines are not protected arms. The second argument was that statistically people rarely fire more than 10 rounds in self-defense situations, so therefore large capacity magazines are rarely used for self-defense, and if large capacity magazines are not commonly used for self-defense, then it is not a protected arm. The court really called out the state of California on their argument, and the court wrote, For the first argument, the state claims that if a standard 17-round magazine is detached from a standard Glock 17 pistol, the 17-round magazine is no longer a weapon by itself. And because the Glock 17 pistol could still function with a substitute 10-round magazine, then the 17-round standard Glock magazine does not come within the definition of arms that the Second Amendment protects. In contrast, according to the state, a magazine holding 10 or less may qualify as a protected arm, but a magazine able to hold 11 or more is not a protected arm. Now, here is the best part. Judge Benitez wrote, "What the state seems to be really saying is that a magazine may be a protected arm, but only the state has the right to pick the number of rounds a citizen may have in his gun." As to the second argument made by the state, the court really digs into it and lets the state know just how pathetic their argument is. In supporting their argument, the large capacity magazines are not protected arms because most self-defense shootings use less than 10 rounds. The state relies on a statistician's conclusion that an average of only 2.2 rounds are fired in an average self-defense situation. Therefore, the state's position is that because more than 10 rounds in the average situation are not being fired for self-defense, the argument goes magazines holding more than 10 rounds are not used or needed for self-defense. And because the Second Amendment protects only those arms commonly used for self-defense, the state says larger capacity magazines are not commonly used and therefore they are not protected arms. The court seemed to find this whole argument laughable and wrote, "It is a remarkable reading of Heller, McDonald, Catano, and Bruin to say that if a gun is not fired more than 10 times in self-defense, then the gun's larger magazine is not being used in self-defense. And if not used in self-defense, then not protected by the Second Amendment." Yet, this is the state's theme. In this court's view, it is a crabbed reading of the Supreme Court's Second Amendment decisions and not relevant to the text, history, and tradition test. The Supreme Court uses several descriptive phrases to describe the kind of firearms that are protected by the Constitution. But common to all is the notion that to be protected, an arm needs only to be regarded as typically possessed or carried or commonly kept by citizens to be ready for use if needed. The Supreme Court has not said that the actual firing of a gun is any part of the test. Indeed, the Second Amendment does not say that the right of the people to keep only such firearms as they actually shoot shall not be infringed. The court went on to determine that because millions of Americans possess large capacity magazines for self-defense, the fact alone entitles large capacity magazines the protection of the Second Amendment. And when a magazine commonly owned by Americans with the subjective intention of using it for self-defense, it is enough to say that it is in common use or typically used for self-defense. Next, the court tears into California's 2.2 shot average statistic. In his order, the judge writes, "Where does the 2.2 shot average originate? There is no national or state government data report on shots fired in self-defense events. There is no public government database. One would expect to see investigatory police reports as the most likely source to accurately capture data on shots fired or number of shell casings found, although not every use of a gun in self-defense is reported to police. As between the two sides, while in the better position to collect and produce such reports, the state attorney's general has not provided a single police report to the court or to his own expert. Without investigatory reports, the state's expert turns to anecdotal statements, often from bystanders, reported in news media and selectively studied. She indicates she conducted 2 studies. Based on these 2 studies of newspaper stories, she opines that it is statistically rare for a person to fire more than 10 rounds in self-defense and that only 2.2 shots are fired on average. Unfortunately, her opinion lacks classic indicia of reliability and her 2 studies cannot be reproduced and are not peer-reviewed. Reliability and validity are 2 aspects of accuracy in measurements. In statistics, reliability refers to reproducibility of results. The court did not stop here. The court noted that Allen's 2.2 shot average is suspect for larger reasons. The whole statistical exercise is based on hearsay upon hearsay news reporting rather than police investigatory reports. A database of news articles lacks the usual indicia of accuracy and reliability of admissible evidence. Well, after the state of California fell short on those arguments, they then changed gears and tried to argue that magazines that hold more than 10 rounds are unusually dangerous. In my opinion, this was somewhat dishonest arguments because what the state was trying to do is change the dangerous and unusual test created by the United States Supreme Court to determine if certain weapons that are not in common use by law-abiding citizens can be banned consistent with the Second Amendment. The court correctly pointed out that the correct test is dangerous and unusual and not dangerous or unusual, and that across the country large capacity magazines are used by millions of law-abiding citizens, so they could not be considered unusual. Lastly, the state tried to argue that the large capacity magazines should be banned because magazines that hold more than 10 rounds are most useful in military service and therefore can be banned. As to this argument, the court wrote, Heller made the logical connection between weapons commonly possessed by law-abiding citizens for lawful purposes that would also be useful if necessary for military purposes, i.e. in the militia. Since Miller, the Supreme Court has enlarged the breadth of firearms protected by the Second Amendment to include commonly owned firearms useful for the core right of self-defense and other lawful purposes like hunting, sporting, and target shooting. Until the Supreme Court clearly says otherwise, commonly owned weapons that are useful for war and are reasonably related to militia use are also fully protected so long as they are not useful solely for military purposes. Firearms with magazines holding more than 10 rounds are such reasonably related arms. Even Miller understood the Constitution to protect the possession of ammunition. For the militia system to function, the possession of arms also implied the possession of ammunition, and the authorities paid quite as much attention to the latter as to the former. All considered, the best reading of arms includes magazines. The court did a great job explaining how the magazine ban was unconstitutional under Bruin, which starts on page 36 of the order. I'm not going to go into all of that because what I really wanted to do in this video was to share with everyone how desperate gun grabbers are getting and how far they are willing to go with their arguments to accomplish their agenda of disarming the law-abiding citizens. In fact, even after being, in my opinion, laughed at by the court in its order, the state of California is still not willing to give up. This past Tuesday, September the 26th, the state of California filed an emergency motion for a stay pending an appeal and for an interim administrative stay. I will attach a copy of their motion down below in the description section for anyone wanting to read it, but this goes to show you just how far the extreme left and gun grabbers are willing to go to infringe on your right to bear arms. Let us know what you think about this surprising 2A victory coming out of California down in the comments section, along with any other questions you may have about this video or any other Second Amendment related question. Until next time, stay armed and educated.